But, Kim Kardashian is probably the most obvious example of someone who had to pay real money and real prices. It wasn't just simply an injunction to stop her from making the endorsement. She had to pay real money to kind of get out from under the liability that she potentially created.
Hi, you're listening to Disputed, a Norton Rose Fulbright podcast. In this episode, we're talking with Aaron Brown and Vic Doman about deceptive marketing practices, and in particular, misleading advertising by influencers on social media. Advertising has come a long way since the days of driving down the highway and seeing billboards. Influencer advertising is quickly becoming one of the most pervasive and effective forms of marketing out there. The Canadian Competition Bureau and the U.S. Federal Trade Commission are concerned with ensuring that posts by influencers are not misleading, including as to whether they have a connection with the brand in question. Aaron and Vic provide us with their takes on key areas that regulators are concerned with, penalties for influencers who engage in misleading practices like not disclosing brand connections, and also talk about regulatory similarities and differences in the U.S. and Canada. And of course, they also share best practices for influencers and companies alike. Aaron Brown is a senior associate in our Ottawa office whose practice focuses on a wide variety of regulatory issues, including competition, antitrust law, international trade, economic sanctions, and export controls, as well as customs and procurement. And she's an avid consumer of social media herself. Vic Doman is a partner in our Washington, D.C. office, a government and antitrust investigations and prosecutions lawyer. As a former enforcer, Vic has a unique perspective into the priorities of government agencies, as well as the challenges clients may encounter. Regarded as a top 3 U.S. antitrust enforcer, Vic previously worked for the Tennessee Attorney General's office, where he served as its senior antitrust counsel. And if you're looking for more information, check out our episode notes, where we've linked to the FTC's guidelines for social media influencers and to the Competition Bureau's guidelines for influencer marketing. In fact, in March 2023, after this episode was recorded, the FTC issued orders to social media and video streaming platforms regarding their efforts to address the skyrocketing claims of fraud by consumers in this space. The Commission also made clear that it is concerned with ensuring social media and video streaming platforms are taking measures to ensure that consumers are able to more easily identify advertising as such, which is a key theme of the discussion in this podcast. We hope you enjoy.
Aaron, Vic, welcome to the podcast. Thank you very much for joining us.
Thanks for having us.
No, my pleasure. It's great to be here.
Okay, let's start off high-level basics. Why listeners should need to pay attention to this episode. Can you explain to us what is influencer marketing and why it's caught regulators' attention in the recent years?
Absolutely. So, I think that people should be listening because influencer marketing is, in my opinion, at least as a consumer, one of the most pervasive forms of marketing that has ever existed. And when I think about this, I often think about driving, down the highway, or, this is across border panels. So I'll say the freeway, I guess, Vic, driving down the highway or the freeway. You see that big billboard for a pop or a soda. I have never seen that billboard and then driven directly to the corner store to purchase the pop that was advertised there. But on social media, I do the equivalent all the time, right? I see an influencer on any of the social media platforms that we think of. Typically we're thinking Instagram, Twitter, YouTube, but of course new platforms are popping up all the time. Us, non-Gen Zers can't keep up with all the new platforms, but we see this happen all the time where an influencer that we follow posts a recommendation of a product, and then before we know it, it's click, add to cart, and it's on my way to my house before I even really think about what I've done, right?
So there are 5 things that I bought this week. Just
exactly. So you're a perfect example of this trend, Ailsa. And so this is just such a pervasive form of marketing, in my opinion. It is such an effective form of marketing. So I think it's really interesting, if you're listening either as a consumer to be aware of these things that are going on, or as a brand that is marketing to consumers through social media channels. This is a really relevant area to be considering and to be seized of. And one of the things that I think is the most interesting from a competition law perspective is that we've long talked about misleading advertising as an area that our regulators are seized of, right? If an ad is misleading, is it providing a representation to consumers that is inaccurate that we're concerned about? But when we get to influencer marketing, we actually have a whole other threshold question of misleading advertising before we even get into the actual nature of the advertisement itself. And that threshold question is it even clear that we're consuming an advertisement? So if I go back to my billboard example, we all know when we see a billboard that we are the target of a paid advertisement, that a company or an organization has paid to put that advertisement in front of us. That's not always, that line is being blurred on social media. We're not always sure. Is this a bona fide, legitimate product endorsement by somebody that I trust that has used this product, that thinks it works great, and I'm buying this product based on their good faith, the same way that I would a friend recommends a product to me. Mm-hmm. So we're not sure if that's the case, or if they're being paid to represent that product to us, to promote that product to us. And if they're getting paid, there's a whole range of potentials there. Is it that they're getting a kickback if I purchase the product? Is it that they got the product for free and they don't want to, stop that sugar train from a brand that's sending free products out? Or is it that it is a fully paid advertisement the same way as that billboard? So it's a pervasive form of advertising that consumers and brands need to be seized of. And it's also a really interesting legal area that is emerging when we're thinking about misleading advertising.
Mm-hmm. Yeah, gone are the days of the kind of madman and madmen engaging a kind of commercial advertising agency that is presumably more up to speed on the regulations and the laws that govern what they can and can't do. She said this is not just pervasive in the amount of people that it reaches, but it's also the type of people who are advertising is way more diverse, and it's presumably a bit of a, not just a nightmare for consumers and brands, but also for regulators as well, and trying to monitor and think about how to manage this.
No, and just building on what Erin said, I mean, we know that social media influencers now have reached an all new high level just because Netflix has created a show about it, right? Emily in Paris is all about influencer. I mean, if there's anything else that tells you that influencers are now prime time, that's the case. I think if you also ride on a train, ride on a bus, ride on a plane, everyone has their phones open and they're on any one of the number of social media platforms. And I know none of us would ever do this, but if you happen to peek across the aisle, you can notice people scrolling through, and half of the time they're looking at videos. The other half of the time they're seeing advertisements from those platforms. So it is so pervasive in just daily life, much more than, say, the billboard on the side of the road or the television with the periodic advertisements. Now, as you scroll through your phone, it's coming to you constantly. It's really almost difficult to get away from it. And with that, there really are probably some new, oversight that's necessary from the agencies, or the feeling by the agencies that we should have more oversight over social influencers, social media influencers.
I always say as well, it's not necessarily a bad thing, right? It's actually quite helpful having all these products, like your attention directed to products that you're interested in, and to see somebody that you already follow or that you're already a fan of try something out before you buy it. That in itself is not necessarily unhelpful. So I think we need to still keep in mind that this has potential to be a very valuable advancement and progress in the digital economy, but it's just how it's managed and how it's regulated, and to ensure that the risks to consumers are minimized. So I think with that, Erin alluded already to certain competition laws and regulations in place already. Can you outline or do kind of compare and contrast the legal landscape across the US and Canada, in particular looking at the legal frameworks through which regulators are looking at online advertising and digital commercial activity?
Let's talk a little bit about the U.S. just to get started. And it's certainly similar in Canada. I know Eric can speak to that too. But here in the States, the Federal Trade Commission is the agency with the majority of enforcement authority over consumer protection violations, right? And so under the FTC Act, there are various things that fall into that trap. And so what you'll typically see is when there is any attempt to unfairly influence or deceive someone, then the Federal Trade Commission will probably step in and say, wait a minute, we've got an issue here. And through that, what they've done is they've issued a number of guidelines and rules that try to help not only consumers, but also the advertisers themselves and anyone else who might think about giving an advertisement or being an influencer of some sort. And so thankfully for I think people on all sides of the platforms themselves, the FTC has actually put out some very handy guidelines that can help the average influencer or the average advertiser understand exactly what's okay and what's not okay, and what might subject you to some level of penalty. And if you take a quick look on their website, you can actually find this very quickly. You do a quick Google search, hate to say it, and you can find it just like that. But I think that one of the things to consider is that use some common sense. Use some common sense. If you're a social media influencer, think about exactly what you're saying and why. And so the FTC has really made it clear that, for example, if you're getting paid for it, you need to let people know about it. If you haven't used the product, you probably shouldn't be making statements about how wonderful and terrific it is. But if you have used the product, be honest and tell the truth about what you feel about it. I mean, these kinds of influences have gone back, for hundreds of years. It's just that on the social media platforms now, it's very, very different. And I think that, in the US, and I'm sure in Canada too, I mean, the old snake oil salesman has always been the example, right? There's someone who has a product that they're promoting that they don't even think probably works the way it should, but they sure are going to tell you how wonderful it is because they're getting paid to do it. And with that, there are certain dangers that consumers unwittingly or unknowingly may step into, and the FTC wants to make sure that everyone knows the ground rules before you step into that world.
Mm-hmm.
Yeah, so it sounds like there's a lot of similarities to the landscape in Canada. In Canada, really, we think in terms of misleading advertising, we're normally looking at the Competition Act, which is enforced by the Competition Bureau. And similarly, the Competition Bureau in Canada has released its own influencer marketing guidelines. And it's really sort of like that same, common sense perspective that Vic was talking about. It's really kind of like that gut reaction test, right? So specifically what the Canadian Competition Bureau has really focused on is disclosing all material connections, is the way that they put it. And so if you have any type, if the influencer has any type of material connection with a brand, that needs to be disclosed to consumers, to followers, to subscribers, whatever to consumers essentially. So that could look like a lot of different things, that material connection. It can be anything from, a personal or a family relationship with the brand, could be free event tickets, free trips. It could be discounted products or free products or services. It seems brands send a lot of free products to influencers to get them to encourage them to post about it. So if an influencer even is just getting free or heavily discounted products from a brand, discounts outside the regular discounts that consumers would get, that is a material connection to a brand as far as the Bureau is concerned. And then, of course, any money that's paid. So if it's a full-on, brand partnership with paid sponsored content where, it's more similar to our billboard example where you have a photo shoot and all of that, everything that goes along with that. And it's really a monetary advertisement opportunity. That's obviously a material connection. And then commissions as well. So, if you are going to get a cut of the pie every time a consumer is clicking on that link on your story. And, as Ailsa said, she purchased 5 things in the last week. Well, did the influencers that posted those links get a cut of Ailsa's, purchases? So that's a material connection as far as the Bureau is concerned as well. And there's a couple, the Bureau has gone a little bit more in detail. I mean, it's not incredibly detailed, but it does provide some high level guidance on what it would like to see in terms of what these disclosures of material connections look like. So they want these disclosures to be visible. And so, anybody who's been on Instagram recently knows that, some influencers might post, 15 or 50 hashtags on a static post. You can't just have one hashtag ad buried at the very end of that, sequence of 50 hashtags. That's not going to be visible and clear. It should be prominent. You know, the Competition Bureau specifically says it can't be just, one in a long caption, a group of hashtags. It needs to be visible on all devices. Specifically, they would say without having to click or tap a button to expand the post. And, as Vic was saying, I think there's a common sense or a gut test here. As we see the platforms and the nature of platforms start to evolve, we need to reconsider what a prominent and visible disclosure is. So on a static story, a static post on Instagram, which used to be the norm, what is clear and visible in that context might be very different from what's clear and visible now when really stories have taken off on Instagram. And that, that gets into some of the other point, which is that, it should be, the disclosure should not be separated from the content. So if you have a story that spans 3 or 4 different slides and you just put ad on the first one, but it's open to your followers or to consumers to share those other stories, that other content that doesn't have the disclosure, and that, is shared a lot of times on social media, and you lose the initial disclosure, that can become a problem as well. So it's really that gut check and, making sure that the disclosures are clear, contextually appropriate. And as Vic said, really thinking about it from a common sense perspective. What would a consumer who's viewing this post or this, YouTube video, et cetera, think is my connection to this brand?
Yeah, and picking up on that too, in the U.S., I think it's important to recognize that the Federal Trade Commission uses the same term, right? Material connection. That is it, and I think that's really what you have to keep in mind. One of the things that Aaron was touching on too is that, if you're an influencer, just don't assume that your followers already know about your brand relationship. Just because they may think you work for a certain brand doesn't mean they have to, and that doesn't get you off the hook in trying to issue that disclosure, right? You cannot assume that your folks already know it. And second, even if you think you're, as an influencer, that your opinion is kind of unbiased, you still have to make the disclosure, right? You just can't say, well, I'm completely objective and I just think it's the best product in the world, so I'm going to use it anyway. And because it's the best product, I don't need to tell my consumers that I've gotten paid to promote it. That's not good enough. You actually do have to disclose that relationship too. And I think that's something very important to keep in mind. You may know everything about the product, your consumers don't. They're looking at you for some advice, and you do need to really let them know that, in fact, you have received some kind of material, you have some material connection to that product, not just simply you picked it up off the shelf and think it's wonderful.
It's interesting. It seems like these regulations address at least 2 things, 2 sort of principal concepts. One is making sure that influencer marketing is regulated like any other advertising and marketing would, like a Subway commercial or a movie trailer, or commercials between segments on TV. So that's one piece of it, and then the other piece is getting over this idea that people on social media might be deceived into thinking that someone that they follow who's holding a product just so and going on about its virtues isn't doing that for compensation, is doing that because they just genuinely believe that it's valuable. And it strikes me that it has the effect, or potentially has the effect, of just making all influencer type marketing very much consistent with sort of traditional endorsement deal style marketing, where everyone is supposed to be completely in on the joke that, of course, you're being paid to do this. Of course, this is a commercial thing and it has nothing to do with your genuine love of the product. But I guess that's okay. One just wonders whether it defeats the purpose to some extent of so-called influencer marketing in the first place. But that's more of a commercial question and a speculative one than anything legal.
Yeah, but I think your point and touching, and I had some similar thoughts coming from what Vic was saying, is I think, we sort of think about it in 2 different ways, right? Is I think that the new aspect here with influencer marketing is we have this threshold test of whether it's clear that it's even an advertisement to begin with. And then we still have the normal misleading advertising, is the content misleading? So if I'm an influencer and I'm promoting a skincare product and I say, this skincare product is revolutionary, it will make all of your acne or your blemishes disappear for sure in, a matter of days. Well, that is, even if I've made clear that I, have a material connection to the brand and I've disclosed that, we still have the question of the content of my actual advertisement. And of course, as with all advertised, as with the normal course of misleading advertisement, the advertisement, if you're making performance claims, for example, it needs to be based on adequate and proper tests, and all of those sort of normal rules apply to the actual content of the advertisement. But I think you're right, Andrew. I think we're moving from a space or a time when people, follow these lifestyle influencers and really thought that they were just sort of giving these unbiased, genuine, well, I don't want to say not genuine, but unbiased, or, just
objective.
The type objective, just like
Yeah.
the type of recommendation that your best friend would give you after they used a product that they liked,
Because
we have to recognize
that's a real category, right? Like that's a real online influencer category, which is YouTube reviews of video games,
Yeah.
or skin products, or clothing lines, or anything. That's a real thing that exists, and differentiating between that and the one that's got a SpawnCon tag at the bottom is actually pretty subtle to do.
Right. And that's why that disclosure of the material connection is so important, because there still are people out there who may be making YouTube videos reviewing a bunch of power tools, and they're just going to the store and buying those power tools and trying each of them and giving you their unbiased opinion. But if you don't have that material disclosure for the other types of advertisements, then, that's where it starts to muddy the waters. I'm not really sure what the YouTube videos on power tools are about. That's not where I typically spend my social media time. I can tell you a lot about the fashion influencers on Instagram personally.
I think I actually do use YouTube reviewers a lot, particularly for board games, actually. I find it very helpful.
That's another conversation, Elsa.
I know. Where it seems to me that so much of the risk is, particularly when thinking of for brands in particular, is that we're relying on the judgment of individual influencers here to determine, is this a material connection? Have I made a sufficient disclosure? And I think that is, particularly from a brand's perspective, how do you know they are making the right judgment call? They're not well versed in what constitutes material connection. They're not well versed in what constitutes sufficient disclosure for misleading for advertising law purposes. So, whose responsibility is it to educate the influencers on the requirements, and by extension, where does the liability fall with that responsibility?
I definitely don't think that brands should just be relying on influencers to make these determinations. I think brands need to be taking an active role in shaping this. So for brands that are involved in social media marketing, that work with influencers, particularly consumer-facing companies, I think, this is the time, if not already, to develop and maintain those influencer marketing policies and guidelines. Work those into your contracts with influencers. When you, to the extent that you are sending out free products or heavily discounted products or loaned products, include, if you're including a specific hashtag that you would like them to use, make sure that the guidelines are clear there, that you expect them to be disclosing that this product was provided for free or for a discounted rate, whatever the case may be. If you're sending free products, include an insert with exactly, the guidelines to the influencer about how you want to see that represented on social media, that you want that disclosure to be clear. To the extent that you're working with marketing companies or with influencers directly, make sure that that's clear in their contracts, what you expect of them in terms of the clarity of their posts, the clarity of those disclosures of material connections. Send them reminders about that. Send them updates every time you update your policy. And then a big part of this as well is going to be track that. Make sure that you are then going back and checking what is being posted by influencers that you work with, or by, brands may want to be searching via, common hashtags that are used with their brand to take a look at how this is actually playing out on social media. Is it clear? Try to put those objective glasses on and say, okay, if I'm a consumer that doesn't have the details of this relationship, can I discern from what's available on social media that this product was free or discounted or borrowed, or that the event tickets were given freely, or that this is a paid sponsorship? So I think companies need to be companies in the influencer marketing space, and companies in consumer products need to be taking an active role on this. They cannot and should not be relying on influencers to make sure that that there's no compliance risks here. Influencers come in all different shapes and sizes. There's many very sophisticated influencers that may have their own legal teams that are seized of these issues, that may regularly make connections very clear. But it's a spectrum right now where other influencers that are just entering the space may not know these rules yet. Hopefully they're listening to this podcast and they will know the rules soon. But I think brands need to be taking the bull by the horn.
Yeah, and just to kind of build on that, I think to go to your question too, Elsa, is that I think when it comes to who might be responsible or liable, I think it could be the producer of the product, it could be the influencer, and it could be the platform, and all of the above. I think that's the big thing. So this responsibility really falls on everyone. And I do think that, as Aaron said, some influencers wouldn't know this. More the sophisticated ones certainly do, and they make sure it's on there. But some of the tech platforms themselves have taken, kind of this to heart as well. And so, for example, Instagram, if you're on Instagram, you're going to see something like paid partnership with. I mean, some of the tech platforms have tried to get out in front of this too, because they recognize that they could be held responsible as well. And they're trying to avoid that as much as they can. They're in the crosshairs for so many other things that if this is one less thing they have to worry about, they'll be happy. But as I said, to answer your question, I think everyone in that chain of delivering that message could potentially be liable, at least as far as the FTC is concerned, and I'm sure in Canada as well, Competition Authority.
So, but Vic, that's a perfect jumping off point to talk about consequences, right? What are the consequences if you're an influencer, or you're a platform, or you're a consumer packaged goods, or any other developer, seller, maker of something that's going to try to disseminate it through influencer marketing? What are the consequences of a foot fault here, or worse than a foot fault? What's going to happen?
In the U.S., of course, there are all kinds of things. And one thing we haven't really mentioned yet is that, we've mentioned the Federal Trade Commission, but there are other agencies that can get involved as well. For example, the SEC, when you have some kind of violation, for example, in the crypto world, and Kim Kardashian was a perfect example of this. She was advertising without revealing, the fact that she had been paid by the cryptocurrency firm to represent them or to promote them. And so she was fined $1.26 million. Plus, she had to disgorge any profit she made, plus interest, and she had to cooperate in an ongoing investigation. So it's not just the Federal Trade Commission, which typically would issue some kind of injunction or penalty for this, and that's really the extent of their authority. But it's other agencies as well that have real hammers to really drop on an influencer or someone such as a Kim Kardashian. I think, crypto is probably the best example now, because, you've had people like Tom Brady and LeBron James and Matt Damon and Larry David all doing ads for cryptocurrency, and we see what can happen with that, right? I mean, I guess Tom was doing something for FTX, and we know what's happened there. But and you've kind of seen a quieting of those. I don't know if we see quite as many of those right now in the crypto world, but Kim Kardashian is probably the most obvious example of someone who had to pay real money and real prices. It wasn't just simply an injunction to stop her from making the endorsement. She had to pay real money to kind of get out from under the liability that she had potentially created.
Yeah, and I think we're going to, we certainly have the potential for big money to be on the line in Canada as well. Actually, there are fairly recent changes to the Competition Act that came into effect last June that actually increased the fines and penalties, including for deceptive marketing practices. So, we now have maximum penalties that range in the range of $750,000 for individuals, $1 million for subsequent violations, and it's the greater of $750,000 or $1 million for each subsequent violation, and 3 times the value of the benefit derived from the deceptive conduct, if that amount can be reasonably determined. And then, the maximum penalty for corporations, we see a maximum of $10 million or $15 million for each subsequent violation, and 3 times the value of the benefit obtained from the deceptive conduct. And if that amount cannot be reasonably determined, the maximum penalty is 3% of annual worldwide gross revenues. So, there's some pretty big dollars on the line here. Previously, before these changes to the law, penalties were capped for corporations at $10 million. But we're certainly seeing at least the ability to have some pretty significant teeth come into, to help the Competition Bureau enforce misleading advertising, including in the social media space.
And one thing I haven't mentioned too, which I should have given my past, is that in the U.S., in addition to the Federal Trade Commission, we also have the state's attorneys general. And so all of the state AGs also typically they have a Deceptive Trade Practices Act too. It's kind of a mini FTC act. And under all of those in different states, there are all kinds of different penalties ranging from, say, $1,200 per violation all the way up to $1 million per violation. And what's a violation? Is it every single time that your post is viewed by a consumer in California or in New York or in Florida or in Texas? Or is it just, once you did it once, you're done? But that's another addition to all of this. We really focus on the FTC, who's kind of leading all this, but every state has a consumer protection law too. And if, for example, California and New York decide to join the Federal Trade Commission, which they do sometimes in an action, you could see additional penalties and fines, which vary wildly from state to state. And it's just something that you don't want to forget as the states continue to become more and more active in this world.
I think that point touches on another point about jurisdiction and these issues and these claims, because this is online, it's pervasive, it's global, it's everywhere. And I think that is something that is particularly important for brands and influencers to be aware of, is that you could be facing regulatory action and civil claims in multiple jurisdictions. So say, for example, we take the example of an Ontario incorporated company, an influencer that's based in, let's say, California, and the audience or perhaps a consumer buys a product from that company marketed by a California influencer, but the consumer themselves is based in England. You're potentially engaging 3 different, or maybe even 4, if you want to add federal on top of state jurisdictions there, and who knows how many regulators. And then on top of that, you've got the product, the nature of the product itself, influencing who the regulator might be. So for example, even and I think in that situation, people might not actually be aware of the types of laws and regulations that can engage, and the securities is an example with Bitcoin, and the whole debate around to what extent a cryptocurrency is a security in itself and the extent to which it engages the SEC. But also something like even a skincare product might attract the attention of the FDA, for example. And I don't think that's something that individual influencers who aren't legally trained in most cases would be aware of.
Yeah, I think there's certainly a lot to unpack there, Elsa. And it's interesting that you mentioned, skincare products, and that gets me thinking about health products. And certainly, health claims have been something in Canada that are especially sensitive, particularly because, that's a heavily regulated area. With Health Canada involved. And during COVID-19, the Competition Bureau worked closely with Health Canada, for example, to crack down on unlicensed and unsubstantiated claims relating to COVID-19 prevention and treatment. So you have, some specific dynamics there around the healthcare industry. But with respect to your question of jurisdiction in terms of geography, I mean, my sense is that these are really consumer protection laws. So if you have a consumer that is located in a jurisdiction, I don't think as a business you can wash your hands of it if the paper trail shows that these advertisements were reaching a consumer in their jurisdiction. Then I think that my sense from a general standpoint is that it is going to potentially lead to these very international, situations, and you can't just sort of wash your hands of liability as a company because you have a consumer in a different jurisdiction. I think, Vic is maybe well suited to talk about some of the enforcement given his past, but I do think we will see, and we have to some extent seen, some cooperation between the competition enforcers across different jurisdictions.
Yeah, and really just to pick up on that, I think when you think about it as an enforcer, they absolutely think they have authority. So don't ever forget that, and they will test the bounds of what that authority might be. In fact, the guidance that the Federal Trade Commission gives says that they do have it, and that's guidance they're giving you is beware, because if you send something, it bounces from Canada to London to California or Washington, D.C., you can guarantee the FTC is going to say you are under our jurisdiction now, and we're going to do it. And the states are no different, right? If you've got that social media advertisement or post in California, you can imagine the California AG is going to say it's affecting my consumers. And even if the Federal Trade Commission doesn't do anything about it, I will. So that's really the way to think about it. If you're an influencer or a product producer of any kind, just think about the way an enforcer is going to think that they have the authority to bring you in and tag you, and they will see how far they can push their statutory authority. And so you don't even want to get caught up in that if you can avoid it. And I think that's one of the things to really consider. The other thing to point out, tagging on to what Aaron was saying, is that absolutely the enforcers talk. I mean, so the Department of Justice, the Federal Trade Commission, the EC, Canadian Authority, the state AGs, they're always talking, whether it's a competition issue or a consumer protection issue. They have regular meetings, regular discussions. They're sharing information so that if it may not be helpful for someone at the EU or the CMA, it may be helpful for someone in Washington, D.C. And so don't ever think that there aren't as many lines of communication as possible. I know when I was with the enforcers, it was a regular thing. We had regular calls and regular discussions with other enforcers around the country and around the world. That's just what's going on.
That's globalization for you, right?
And the classic, I like how you refer to these agencies as enforcers, Vic. The classic enforcer tactic of aiming for the head, aiming for Kim Kardashian to send the most public, visible message about what can go wrong for you if you run afoul. I mean, that would have more impact than 100,000 micro cases against people doing travel influencing on Instagram or whatever it is, just to have the maximum reach. It's sort of the irony of the advertising reach itself is how much the message from the enforcers lands when you land it against someone with that much public availability, let's say.
So I think taking Andrew's point about the regulators kind of going for the head and making an example of somebody, I think what we've also seen is the rise of cancel culture too. And actually, we see a big movement amongst followers at the moment where there is an influencer that hasn't made appropriate disclosures. There's a kind of cancel culture, or there's the cancellation movement towards or with regards to that individual. And I'm thinking most recently, I don't know if you've heard about Mascara Gate and what happened. This is the latest one, where there was a TikTok influencer who failed to disclose her connection with the brand L'Oreal about this mascara that she was using, and she claimed it was wonderful, but then there are lots of people saying that she was wearing false eyelashes in the video where she was demonstrating that product. And rather than, I don't think there's been any kind of regulatory action per se with regards to that conduct, but actually what we've seen is a lot of consumers refusing to follow her or cancelling her effectively because of the misleading advertising that she's. So it's having a kind of cultural impact. This, if this isn't just the regulators coming down, with the hammer on it, we're actually seeing a kind of grassroots movement against misleading advertising too here, which I think is really interesting.
Well, I think it might partly be consumers becoming wise to this, right? And consumers realize that, like, there was this slow sort of trend where at the beginning, there was this sense that, oh, maybe people are just promoting things without having any sort of like kickback to them. It's just their bona fide review of this product. And now I think consumers are realizing that that's not the case, and they do want transparency. And I think, anecdotally, I think influencers that are very clear and are very transparent with their followers and say, I am getting paid by these brands, but I'm only going to promote things to you that I actually do fully endorse. I just happen to also, have a great partnership with that brand. I think we're going to see people vibe more and identify more with those influencers who aren't misleading them. So I think, we all as lawyers come at this from a legal perspective of you want to avoid liability, but I think that there's also a reputational thing here too for influencers and brands, to be in a positive relationship with consumers where where consumers are trusting these influencers too, because they really are promoting brands that they identify with, that they use themselves, products that they like themselves.
But picking up on that, Aaron, I think one of the concerns though too is, we focus on, say some of the sophisticated, consumers out there, but children are on this all the time too, right? I mean, if you look around, the average 12-year-old has a phone and she or he are scrolling through things. And I know we try not to be a parent, but we are in a way. And I think that's part of what the Federal Trade Commission is really trying to do too. And they've given guidance certainly about, targeting ads to children and everything else like that. But your average 12-year-old, even if they see the advertisement logo or not, they just scroll right through it, right? And they're just like, well, so and so did this, so I've got to buy it. I'm gonna use mom's credit card, and I'm buying it right now. And so there are certain things I think that there are certain consumers of the social media influencing that probably need a little maybe a little oversight. and so the FTC puts out these rules to try to help at least limit some of that that influence that gets past the average 12-year-old or 13-year-old.
And I do think that raises an interesting legal question as well when we're thinking about the objectivity standard. So, for example, is your disclosure, would it come across to the reasonable consumer that this is an ad? But if your reasonable consumer isn't the man on the Clapham omnibus, as the English judges like to say, it's actually a 12-year-old girl, to what extent can the brands be held to the same kind of objective standard of determining they've had sufficient disclosure in their advertisements? And I think that's a really interesting legal question. I'm not sure it's been tested yet.
That's true. I don't know that it has, but I think, once again, you talk about the reasonable consumer, and I think that Federal Trade Commission does recognize that, if we go back to the beginning of this discussion, really, and talking about common sense, there are ways that you just are open and upfront about the fact that this is a paid advertisement. I mean, Federal Trade Commission gives you language that you can use, right? It's not, they're not necessarily doing a gotcha. It's more of, all right, if you're paid for it, just make it known. And if you do, you're probably okay. If you try to hide it, you try to be tricky with it, you try to use some tiny, font in a different language, it's not going to work. I mean, you need to be upfront and honest about it. And I think that that's how you can protect yourself from getting into some hot water with Federal Trade Commission in the U.S. or with the state AGs. And you have a cognizable defense to it if you just say paid by, advertised by, just don't try to be too tricky, and you're probably okay, even with kids.
Yeah, I agree. And I was going to, I think that was a great point to bring up the potential to be advertising to all different ages. I think, the Canadian Competition Bureau, the guidelines in terms of making those disclosures talk about disclosures being contextually appropriate. So it may be that if an advertisement is really targeted towards younger people, that maybe what is contextually appropriate in that case is, as Vic said, it's, can be a fairly clear formula, but maybe in that case, it needs to be, for example, a verbal. If you're dealing with children so young they can't read, for example, or what is contextually appropriate might change if you're dealing with children, and you might need to make it even clearer if the ad is truly targeted to young people. So I think, that contextual appropriateness point, I think is important to keep in mind. But it goes back to, as Vic said, like the common sense and that gut check in every case to say, is this appropriate in the circumstances?
And the targeting piece is an interesting part of this that's probably fodder for a deeper future conversation, given the way that you can incisively target on social media now in a way that, previously if you're targeting kids, it's like breakfast cereal commercials during Saturday morning cartoons. But now on social media, you can certainly do a lot more than that to make sure that your content gets in front of the age demo that you're interested in, or the social demo otherwise that you're interested in, which raises in litigation potentially other questions about what you were going for when you put something out in the world, and in that bracket of what you were in, the group you were intending to reach, how clearly you adapted what you were doing for that audience. You guys have given us some really good parameters and bumpers around sort of best practices and thoughts on what people can do to protect themselves from enforcer action in this space.
And maybe I can give a little plug to anybody who's interested in that. I believe there will be a future Disputed podcast episode dropping on that topic.
We just recorded it with Chris Hirsch, so
amazing. So that'll be definitely a must listen to episode for anybody in this competition space who's concerned with the wage fixing and no poach agreements. That's really a substantial change to the competition law in Canada.
So looking ahead, get out your crystal ball.
The crystal ball.
What do you see are the trends looking into the year ahead, the years ahead? What do you expect on the horizon?
Well, I do wish I had a crystal ball, Andrew. It would make life and practice easier. I think in Canada this year, we have a major change on the horizon coming into effect in June 2023, which is, the changes to the competition law governing wage fixing and no poach agreements. So I think that we're going to see, at least for the first half of this year, the Competition Bureau only has so many resources in addition to the normal merger review that it has to do. It has guidelines out right now, draft guidelines on that wage fixing and no poach agreements piece. It's consulting on that piece. My sense is that for at least the next couple of months, we're going to see a little bit more momentum in that space than we will in the misleading advertising space. Now, that could change. If we had a case like the Kim Kardashian case in Canada, who knows? We could see the Bureau take decisive action, to, as Vic was alluding to before, maybe set an example, crack down on that type of action. But, barring any big events like that happening, I see maybe a little bit more focus on at least in the short term in Canada, on that wage fixing and no poach piece, which I think actually makes now a great time for brands to take a little bit of time to look at this social media piece and, get their ducks in a row, because I think at a certain point, once the wage fixing and no poach issues have been, sort of ironed out, we may see the Competition Bureau come back to, looking at this digital space.
I think that, we do have to keep in mind, though, that tech companies are certainly of concern for the enforcers. And as I said, Andrew, you mentioned the word enforcer versus regulator. I do think here in the U.S., they really view themselves as enforcers. They don't want to be regulators. They don't want to regulate everything go on. If they see something, they want to enforce the law. And so they have a very different mindset with it. And the tech companies, outside of healthcare, both the DOJ and the FTC view the tech companies as the biggest targets, and so they do that. But as Aaron said too, they have limited resources and they can't tackle everything all at once. They've kind of brought a lot of their cases on the tech platforms now, and I think there may be another defendant here or there, but otherwise, social media influencing maybe not so much. As Aaron alluded to, here in the States too, wage fixing, no poach agreements, the elimination of non-competes by the Federal Trade, or the attempt to eliminate non-competes in all contracts in the United States, has got everyone really worked up. And of course, the agencies are still supposed to be presenting new merger guidelines. in the U.S., and that's supposed to happen probably within the next month or so. I think so. With those priorities in line and having already brought several tech cases, I think that the agencies might be stretched a little thin to try to bring too many things on against social influencers or anything else like that. But once again, they have just released this guidance, so there's someone in the FTC right now who is keeping notes and is keeping track. And when they have an opportunity, they're going to say, so and so just said this, and we know that's a problem, and let's make an example of them. And that's certainly possible. I just think that it's going to be difficult right now because they have so much on their plate.
Well, and at minimum, if they take nothing else away from this podcast, they know that when that phone call comes from the FTC, their next phone call is either to Vic or to you, depending on which side of the border they're sitting on. Guys, this has been...
Maybe both, depending on, the jurisdictional questions we talked about earlier.
Conference call, bring it all together. That's what it's all for. I'm now wondering, Aaron, who the Canadian equivalent of Kim Kardashian is going to be. Is it Justin Bieber? Is it Ryan Reynolds? I don't know. These are questions for a future discussion, which I hope we can have, because this has been so useful. So thank you guys very, very much.
Thank you for having us. And I do also want to thank everybody who's listening to this podcast right now, because I never expected in my professional career that I would get to talk about something called Mascara Gate or use all of my time spent scrolling social media and call it research. So, thank you to everybody who's made this podcast happen.
Absolutely. Very enjoyable. And I think that it's always fun to talk about this and just kind of a little bit lighter at times than some of the other conversations we have. So I enjoy it. Thank you very much for the invitation.
We hope you enjoyed this episode of Disputed. If you'd like to find out more about this topic or how to contact our guests, please visit nortonrosefulbright.com/disputed. We'll be taking a hiatus for the next short while, but previous episodes of Disputed are always available on Apple Podcasts, Spotify, or wherever you get your podcasts. As always, if you have any questions, feedback, or topics that you'd like us to cover in a future episode, please do email us at disputed@nortonrosefulbright.com. Thanks very much.